she needs to be involved in the discussion. It's obviously the clip, I believe, is about 14 minutes long. So I don't think they'll have an opportunity while we're here today or tomorrow to do that.
Of the two recordings, the substance is the same, just one has, I guess the audio has been, the forensic audio engineer in some way modified one of them
Yes.
to make it clear.
That's,
But the words, nothing has changed as to the substance of what is on the recording.
I think that the enhanced one is more clear. I wanted the opportunity to have my client go through it with us.
All right, if you wish for me to go to the Nelson inquiry, or not, excuse me, not the Nelson, but the Richardson inquiry at this time, I can do so, but you're asking before the item is admitted.
I'm not asking for a Richardson inquiry at this point. The state has already given us the option to choose which of the two versions would be admitted. So I think they're conceding that issue. So I don't think it's ripe at this point. There is a Richardson issue another Richardson issue that arose this morning. Mr. Newland provided me with a flash drive of photographs from the search warrant of my client's condo that was done on November 14th, 2023. The state had previously advised us that there were no photographs. My understanding is that is what Miami-Dade Police told the state. That turns out not to be accurate. I've started going through them. I don't know at this point. I know that was part of our arguments that we were going to be presenting. So
That there were no photos, or that the photos would not show anything?
either one, that essentially that there were no photos. Obviously, standard operating procedure is to photograph when executing a search warrant. So I need more time to go through those. I believe that witness is tomorrow.
Yes.
So my intent would be to go through those in more detail, and tomorrow morning I'll be able to address any Richardson issues.
All right. Well, it does raise somewhat of an interesting issue in that way. Part of the inquiry is the prejudicial effect on your ability to prepare for trial. With having the opportunity to review this evidence, obviously that will mitigate some of that effect. You do not want me to go through the inquiry now.
Just a moment, Your Honor. I need to go through them to see if there would be any prejudice. I mean, I can't stand here before the court and say there's not prejudice. It might actually be beneficial. Until I have a chance to go through them, I'm not going to be able to answer that.
All right, concerning the recording, so that way we have a clean record on this topic. And the basis of having this inquiry at this point would be both based on the appellate precedents of the Florida Supreme Court and the DCA courts. I believe Landry versus State specifically holds even a possible discovery violation triggers the requirement to conduct a Richardson hearing, as the inquiry is intended to flesh out whether there has been a discovery violation. Concerning the recording that was made by, I believe, what was the witness's name again?
No, the recording.
Was it McElveen?
Yes, Your Honor.
As to Mr. McElveen's recording or any audio forensic or enhancement work that he did to make it clear, Ms. Kappelman, one version of the recording was provided, but not the second version, which he later provided to the defense.
That's correct, Your Honor.
So as to the enhanced version, or in some way what Mr. McElveen has worked on, that was not provided. There has been a discovery violation as to that aspect. However, the item was known to the defense as to the original state of the recording. Ms. Kappelman, what were the circumstances of not providing the enhanced version of the audio?
Oh gosh. Apparently I requested that work be done prior to Ms. Adelson's previously scheduled trial with previous counsel. I do not recall doing that, but it seems I did or someone on my team did. It was discovered in the envelope from Mr. McElveen during preparation for this trial and believed to be the attempt to clarify the meeting between the defendant and her son at the pier that we've talked about in the testimony yesterday that was unsuccessful. So only in the pretrial conference of Mr. McElveen did he bring to my attention that we did do a clarification effort of this jail call. So I provided it to the defense when I realized that we had done that and it was in our possession, and I advised the defense that whichever version they wanted to publish is the version that I would go with based on the fact that we were discovering it late.
Very well. Concerning this, the court will find that it is inadvertent since a original version was provided, although a clarified or enhanced version was not provided until the trial had begun. As to whether this is substantial or trivial, do you have any argument, Mr. Hellman?
As I indicated, at this point, I cannot make that representation in good faith. I need to listen to it in more detail with my client in order to do so.
And lastly, as to whether this has had a prejudicial effect on the aggrieved party's ability to prepare for a trial, once again, the original recording was provided to the defense. The state also, as well, has agreed with the defense to essentially let them pick how this evidence would be entered, whether it would be the clarified or enhanced version or the original version. So as to a prejudicial effect, the court will find there is not one. As to any conference that you need to have with your client concerning which will be entered and also presented before the jury, obviously you'll have the opportunity to do so. As to any matters involving the photographs, the inquiry will need to take place, but I will allow you an opportunity to review the evidence if you have any arguments to make concerning substantial, trivial, or prejudicial effect.
Judge, on the open line call, the jail call that we're talking about, we are intending to publish that in whatever form the defense agrees to, either later today or tomorrow at the latest. So I will need an answer before Saturday. It's only a 14-minute call, so I suggest that we take a recess so that they can do that over lunch or whenever Your Honor deems appropriate.
Would you all prefer for the jurors not to come out at 9 o'clock and you go over this call now, Mr. Zellman?
Your Honor, we would need to do it in private with our client.
Very well. We'll put the jurors then on an earlier lunch break. The courtroom will be cleared out and recording equipment that is currently in place will be turned off. That will be your opportunity to go over this with your client.
Thank you, Your Honor.
Any other matters for this morning?
Not from the state, Judge.
Not from the defense, Your Honor.
Jurors are ready. We can bring them up.